here. I came here at 9, 10 of the papers. That's our 6 people. So I was worried that no one would show up, but I'm glad at least some of you decided to raise the rein on this. It's actually harder than it looks. It's tougher than it looks. Okay. So how's everyone doing? Okay. Good. I think you've had 1 exam so far. Is that right? 2. What have you had so far? Contracts and torts 2. Okay. And then I'm next. And then common law. Is that it? Then okay. Well, it's coming up soon. All right. So I appreciate that all of you came. The attendance is usually lighter than I'd like, but hopefully this will be meaningful for you. The purpose of this is twofold. The first purpose is to actually walk you through how I think you should read the question and how I think you should structure your answer. In a way, going over the actual substance of the exam is far less important than going over the process of writing the exam question. Indeed, as I'm sure you will find as you review the A+ answer, is that you think parts of it are wrong. And you say, wait a minute, but I wrote this, isn't this right? And he wrote that, isn't that wrong? And the answer is yes. I've never given 100 in all the years I've been grading. It hasn't happened. I've never had a perfect paper. There will always be parts of paper that aren't perfect, that are even indeed wrong. And I can say with full confidence that there's stuff in here that I don't think is probably right, but it was better than everyone else. So the goal for getting an A in this class is not perfection. Indeed, it's not possible. You're not going to get 100. My mind is far too twisted and warped to allow you to think of everything I'm thinking of. It's true. But the goal is to get as close as conceivably possible to that and to structure your answer in a way. Let me make this point succinctly. You can make up for a lack of knowledge by writing a better answer. This is a dirty secret of law school, which you may already know. This will be the dirty secret for the bar exam. You can make up for a lack of knowledge by writing a good answer. Indeed, in legal practice, right? You may not have the best argument, but there are times where if you can structure your answer in a more logical fashion, you may make yourself in a much stronger position. So that's my primary goal. If we're going to start arguing for 20 minutes over what's a fee simple determinable and which is an executor interest, we can do that. But that's not what I'm primarily going for today. All right. So with that understanding, I want to walk you through. Okay. So when you get the exam, and you should all, if you don't have a copy of the actual exam, you can take one. It's a pile right over there. Feel free to come up and grab one. This one was actually fairly long. It was about it was like 9 pages. This is actually a fairly long one. Sometimes they're 7, sometimes they're 9, sometimes they're 10. So it's really based entirely on whatever I'm feeling like at the time. But the first page will look exactly the same. So you don't have to waste your time reading it. The only difference I have here, I even wrote it with red ink. The red didn't reproduce, but it's recrossed out in your paper. You have 1,000 words for each question. Please do a word count. Do not do a character count. I can't warn you enough. Every year, one student does a character count. So the way you do this in ExamSoft, there's a space that says stats. You click on stats, and it says a word count. Do not do a character count. This is your last warning. If you do it, you get no sympathies from me. Okay. So you have 1,000 words for each question, and we're doing number 2 for today's review. So you can skip number 1. Okay. When you get to the question, again, it's what 50%. Nothing new there. I always give you what I call the framing. Okay, what is the framing? I'm giving you certain facts about the people involved, the places involved, and the controlling law in that jurisdiction. And you'll know it because it says instructions, and there's like a little line over here. The stuff in between that is really, really important. Don't skip over that. Indeed, you should read it first. So what does it say? It says, you're a law clerk for Doug Dougie, a New Jersey judge, okay? You've been assigned the task of sorting out several property issues. This was in that Air Malaysia flights appeared, flight 666. And sometimes I'll name the people involved in the situation. So you have AWOW. I'm a Jersey Shore fan. I'm unapologetic. Every year I teach it, the show gets less salience. But at least in 2014, it had only recently gone off the air. So at least still had some juice left. So you have AWOW, Bookie, Irony, and Fituation. To make your lives easier, I'll very often give alphabetical order names. Not always, but I sometimes do that. You'll never repeat a name either, so there's only going to be one person with an A or B name. That way you don't have to, you can abbreviate A, B, since like abbreviations. It says, you've been asked to write a bench memo, 1,000 words, addressing a sensational case involving Garden State's residents. Okay, New Jersey adheres to all common law property rules, and your statement first. Okay. If you've taken the time to look at all my old exams, a pattern should become clear. I almost always ask you what the common law rules. Almost always. Maybe once or twice at the modern. The reason why is that the common law rules are actually rules. It's not all about fairness and fair dealings and things you can make up, right? There's actually rigor attached to the common law rules that show me you've actually learned stuff. I am not particularly interested in what you think is fair unless I ask you. So that's why I ask about the common law rules. Fairness doesn't tell me you paid attention in class. That says, however, many of the issues presented in this case took place in a different time and place and may not be governed by any of our laws. You know, the first, 3 weeks of the semester, we did cases where there wasn't any sort of statutory law or common law. The foxes and the whales and all this other stuff, right? I always ask at least one question where this is the case. I want you to understand how you can work from sort of state of nature to figure out the allocation of property rights. We spent a lot of time on this, and there are a lot of principles we discussed. This is what I'm asking you for. And it even says he's assuming the natural law and the common law, and they want to know how do you allocate property rights without positive law. Okay. For purpose of this case, assume the court's jurisdiction. None of the claims are barred by the statute of limitations, and the rule against perpetuity does not apply. I know when I have a question involving some sort of time travel, some smartass can say, "Well, statute of limitation ran." Okay, I know that's not the right answer. Oh, New Jersey court doesn't have jurisdiction over Jurassic Park, right? That is not the right answer. Okay, I want you to assume there is jurisdiction. All the statutes of limitations have been waived, and again, when we're talking about property interest from like millions of years ago, life and being plus 21 does not apply. Okay, you can see why I don't ask about RAP, because it screws up all my questions. It makes it very difficult to actually ask you something because this entire example is void under rule against perpetuities because it's life's a million years away. Okay, so that's not going to be your answer. Don't give me anything about jurisdiction or statute of limitations. You're in the wrong class. Civ Pro, go for it. Not here. I'm not. That's not the right answer. If that's what you're right, you're wrong. Okay, so after you read this little paragraph or two of instructions, you should jump down to the, there's a long question, what I call the prompt, okay? Okay, it says, so now the judge has some difficult decisions to make. Here's the law clerk. He's asked you to write a memo of 1,000 words addressing 5 issues. I'm always going to ask you 5 issues per question. I'm very disciplined about this. I think maybe my first or second exam I didn't do this, but I'm in a good rhythm now. It's always going to be 5. The reason why is it makes it very easy for me to grade. Why is that the case? Well, it's worth 50 points. There are 5 questions, 10 points apiece, right? I grade each scale on each question on a scale of 1 to 10. What else? You have 1,000 words, 5 questions. Well, that means roughly 200 words per question. It keeps everything very easy. I don't think I did it quite here, but subsequent exams I've done it more. Is that the first 4 questions are asking about case law sorts of things, and the 5th question explicitly asks you about policy. I haven't taught this particular class in a while, so that's why I'm giving some of an older exam. But if you look at my more recent exams, I always try and make the 5th question more about policy. But there's some policy in here too, which we'll get to. Okay, so the first question. Again, you haven't actually read the fact pattern yet. If you're doing what I say, and you're not required to, but if you follow my instructions, you haven't read the fact pattern yet, but you get clues, you get insights. So it says, though this issue has been moved for 65 million years, Irony asks the judge to adjudicate the dispute between Fituation and Rex. Okay. Did the Jurassic Supreme Court have jurisdiction over Fituation? That is, was the jurisdiction of the GTL Supreme Court, that's Jim Tan Laundrie, then initiated, was the jurisdiction of the GTL Supreme Court valid? Finally, Irony asks Judge Dougie which ruling is better, the Jurassic Supreme Court or the GTL Supreme Court? Explain the positive and negative of each approach in terms of efficiency, fairness, and certainty, and decide which ruling should be adopted. So there's a couple questions going on there, right? You don't know what any of this is about, but you're guessing it's probably about the acquisition of property because it's asking about efficiency and fairness and certainty, right? Also, we discussed, which courts have jurisdiction. I mean, this is not a matter of Civ Pro, but as you'll see in the question, it's actually a question of property law. Okay. Number 2, identify the present and future interests. So now your blood turns cold. You say, "Oh my God, a future interest question." He's asking one. Oh no. Okay? Yeah. Runnymede, and for those who don't know, that's where Magna Carta was signed in 1215, 800 odd years ago. Okay, and we have to figure out the future and present interest for B, F, the king, and the king's heirs. So you should have made something in your notes at that point saying, okay, you have bookie, Fituation, King John, king's heirs with a table, present interest, future interest. And you should be filling that little chart in as you go through the exam and trying to figure it out. Because invariably, I'm going to put the information you need scattered. There'll be a little bit here, a little bit there, a little bit here, and you're going to have to compile it in your own sense. And again, RAP does not apply. Indeed, if you want to be very, I could have been a jerk and not said anything, but RAP wasn't in existence in 1215, so it would not control any of those conveyances. I could have really been a jerk, but I made it clear that it was not yet enacted. Okay, question 3. What about this? We got the Montpelier Foundation. James Madison, his home was Montpelier. Everyone knows Monticello, which is where Jefferson lived, but not too far away in Virginia was Montpelier, which is James Madison's home. So James Madison's estate reopens a suit Madison filed against Fituation in 1787. Okay, we had dinosaurs in question 1, we had Magna Carta in question 2, we have the Constitution in question 3. You can see where my mind goes. It's worked. Okay, and again, the statute of limitation was told. Because this claim was brought prior to the creation of statutory law, please address common law doctrine misappropriation. Okay, this is the INS versus AP case, right? The stealing of the news. Again, the issue of this case is not whether Congress created some sort of copyright statute, but there was a common law of misappropriation of property. Right? We discussed that. Okay, number 4. AWOW brings a suit on behalf of Bookie's estate against a T-shirt shop. That's where the Jersey Shore cast members worked in the first season, at least, for unlawful appropriation of Bookie's image by creating a T-shirt. Okay, this is the Vanna White case, right? You should be thinking about the Vanna White case. Please address the strengths and weaknesses. Okay, so now the 5th question. Queen Elizabeth II, the current monarch of the UK, and a very distant heir of King John. Funny story, since King John signed Magna Carta, there's not been a single member of the British royal family named John. It's considered such a crowning defeat that no one would want to be named after him. That's true. Another interesting story, the last time, the Prince of William's kids are Charlotte and George, right? The last time we had monarchs named Charlotte and George, we dumped some tea into the harbor. There was King George, his wife Charlotte of Mecklenburg, whom she's named after. I went to the British Embassy last year for an event, and that portrait of King George and Charlotte in Washington, D.C., I'm like, smart guys. Anyway, the tour guide was not amused. Not amused. Start dumping tea into the Potomac. Okay, so Queen Elizabeth II files suit to quiet title and Runnymede. Again, you should know this, but quiet title simply means you're asking court saying, who owns this, right? Who owns this? It's not like, shh, not that quiet. It's trying to ascertain who owns stuff. Irony intervenes, and he files suit, says that the Fituation's heirs own Runnymede. AWOW also intervenes and claims John II owns Runnymede. Okay? Please address what interest, if any, Queen Elizabeth, the heir of Fituation, and John II have. So again, you're going to have to make some sort of chart and list. Okay, you have the Queen, you have the heirs of the Fituation, and you have John II. And as you read through the question, these sorts of things should be jumping out at you. Okay, any questions so far? Is that a hand? Any questions so far? No?
Sort of have a question, but we might get to it. You mentioned the chart, present and future interests, but those present and future interests change as people live and die. Do you have like a system for making a chart that's
Well,
adapts?
so the short answer is, at the time the question's being asked, it'll specify when I want it, right? It'll specify at the present moment, right? In 2014, whatever the exam was, right? What are the present and future interests? But the way the question could also be asked is, in 1215, right? Identify the present and future interest in 1215. So if you had been a lawyer in 1215, not that such a profession existed, but if you were, you'd be asked, okay, what are the present interests and what are the future interests? Or I can ask you in the year 2015, right? What are the present? It depends. That's why we have to read the questions carefully. Okay. All right, so at this point, I mean, we're about 20 minutes in. I'm going awfully slow. You should have only read the prompt and the 5 questions. You can do this a little faster when you're not reading out loud and giving entire shticks about teen harbors, but you can do this at a faster pace. So let's actually read through the question. Okay. So it says, 4 friends live on the Jersey Shore in Seaside Heights, New Jersey. And I'll just use letters to make it easier. A, B, E, and F. And in January 2014, the friends depart on a plane, and they're going to Bali. And then halfway through the trip, the plane turns to the left, and they get sucked into a wormhole. This is actually not entirely facetious. Don Lemon of CNN, when Air Malaysia flight disappeared, he actually asked, could it have fallen into a black hole or a wormhole or something? This is CNN, right? Okay, they went to the space-time continuum, and they were sucked into a celestial vortex. There was a bright flash of, there are a lot of New Jersey jokes here, which I will not explain, but there was a bright flash of orange-tinted light. And the 4 friends were no longer in the plane, but they were in a jungle. And they looked up, and they see a dinosaur. And then Bookie screams, OMG, we've traveled back 65 million years. And they find that these dinosaurs were not, dumb animals. They were intelligent beings. Oh, this is funny. 4 of your classmates are watching this review session online right now. Hi, guys. It's funny. I'm glad you could make it. Okay. The king of these intelligent beings approach them and say, look, we are your enemies, and you're not welcome in his kingdom. In that situation, it says, you know what, this is the kingdom of, this is our kingdom. And then they get Rex, the dinosaur. Rex means king, of course. Ignored him, right? Tyrannosaurus Rex is basically the king, right? You should be thinking at this point of the various cases involving, the savages, right? Well, Johnson versus McIntosh, right? When you go to a nation with these, these unintelligent people, can they even have a society? Well, here you have, dinosaurs, and apparently these dinosaurs are pretty smart, right? Now the thinking velociraptor, they think. It's something like you studied before, but usually twisted in a different way. Okay, so then the conflict arises. The dinosaurs have an elaborate method of hunting for the smaller dinosaurs. Each leader would mark off a specific area of the jungle, and they would hunt, and the other packs would respect the markings they have placed. This efficient approach prevented overhunting. Where have we seen this before? The Native Americans in Canada who had the fur trapping, and they would mark out different regions on the trees, say, okay, this is ours and that's yours, right? So you've seen this before. This wisdom was lost on the brutes from New Jersey. The situation stumbled onto Rex's portion of the jungle. He tracked down a velociraptor. Rex was tracking a velociraptor, and he cornered him into a cave. Situation thought about the raptor for a moment, stroked his chin, right? And then realized what he would do. He ran into the cave that was already, he had captured him, strangled it, and smuggled it out. Rex was furious. Though respecting the society, Rex filed a lawsuit against Situation in the Jurassic Supreme Court, seeking a return of the raptor. Okay, this is, roughly Pearson v. Post, with a little bit of Genn v. Rich. If you go through all my old exams, I can only ask this question so many different ways. Right? I mean, actually, I can still get creative, but I can only ask this question so many different ways. You know what I'm asking for at this point, right? Okay. Fituation then said, I won't recognize the jurisdiction of this Jurassic court. Right? Remember, he already established his own sovereignty. This is my nation. I'm not going to respect these foreign courts. He said the dinosaurs are a bunch of savages, and he was now the conqueror of Jurassic Kingdom, and he wanted to civilize your society. This is what John Marshall wrote about in the McIntosh case. So he established a GTL Supreme Court, and he had Chief Justice Ronnie. Okay. So then we have a situation. You have the Jurassic Court issuing a judgment for Rex, and they say that this law should encourage and create incentives for hunters. Right? This is the Pearson dissent. The other Supreme Court said, no, we're going to rule for fituation. We have to promote certainty. Whoever captures it gets it. This was the majority in Pearson, right? One was a dissent in Pearson, one was a majority in Pearson. They started arguing about the case, and then there's a bolt of lightning. This wormhole opens up, and they get sucked in. Okay, so now we're on to the next one, right? I wrote this deliberately that in each time period, there'll be a different question. So when there's a wormhole popping up, we're moving on to the next one. I have a lot of fun writing these. I don't know about you, but I really enjoy writing these. I spend a lot of time. It takes me about a full day and a half to write one of these questions. I spend a lot of time writing these. I actually research history, and there's a lot of historical accuracies in here, which you'll never even appreciate. But I put a lot of detail into these. Okay. The next thing we know, they're in a meadow alongside a river. That's indeed where Magna Carta was signed. She looks, sees a bunch of knights. The barons are forcing the king to sign a parchment charter. And Awau, who I actually had a field trip to the museum that year. That was the reference. I took my students to go. They had at the science museum by the medical center. They had a 1217 Magna Carta. Did anyone go see it at the time? But two of you did. It was nice. I took my students on a field trip. It was nice. So he said, "Look, we're in Runnymede. It's 1215, and the barons are forcing King John to sign Magna Carta. The great Magna Carta is the Great Charter." King John looks across the river and takes a liking to Bookie, her painted face, leopard print tights, and signature hair bump, right? Lonely, as his wife had died, she did, King John asked Bookie to marry him and be his queen. Okay, so now we got marital property stuff coming up, right? She enthusiastically agrees and takes the title of Queen Bookie of Orange. The joke there is indeed there was a William and Mary of Orange. Orange was a region, but the skin fits. So after the wedding, King John executes the following grant. Okay, so now your blood turns cold. We have a future interest question. It says Runnymede from King John to Bookie for life. Okay. Then the fituation is heirs. Okay. But if fituation does not survive Bookie, then Runnymede to King John and his heirs. I'm going to avoid answering so I get to the review, the A+ answer. But, this is not a terribly complicated grant, not a terribly complicated one. But make sure you pay careful attention. So I'll get to it later when we do the A+ answer. Okay. 2 months after the wedding, there's a Mazel tov, right? Bookie realizes she's pregnant with King John's child, who was conceived on the wedding night. Okay, wormhole time. So we jump forward, and we're sucked into the vortex. Actually, it's funny. James Madison referred to a government that passes so many laws that people can't understand what they are as a vortex. So that was a particularly fitting one for this one. They suddenly appear inside a 3-story white building with all the windows shut and a guard watching the door. Indeed, the Constitutional Convention of 1787 was done in absolute secrecy. They actually shuttered the windows and had guards stationed at the door because they didn't want people knowing what was going on. So democracy, right? No, we've never had one. We ought not either. They see a group of men discussing how to form a new government. And it's a situation. It's 1787. They're writing the Constitution. Wonderful. Fituation sees young James Madison taking notes and proceedings in a journal. So this is actually the interesting trait, right? One of the best records we have of the Constitutional Convention comes from James Madison's journal. He kept very detailed notes. But the interesting part about this is it wasn't released until after his death. And there's a new book by Mary Bilder called Madison's Hand or something like that, where she argues that Madison actually altered his own notes to make himself look better. He basically altered the notes to make things that other people said in his tongue that turned out to be right. And they basically shaded it to make him and Jefferson look better in hindsight. Controversial. In some parts of it, maybe, I don't know. I haven't read the book yet, but it's controversial. But this is one of the definitive accounts we have of how the Constitutional Convention went down. Situation when Madison's not looking, swipes the journal, and he copies the entire book. He then sold the copied notes to the Pennsylvania Packet. This was actually a newspaper at the time that competed with Benjamin Franklin's newspaper, the Pennsylvania Gazette. Franklin was a printing press owner. He printed a lot of newspapers. Madison then learned that the Situation stole his journal and republished it. Madison told him that the proceedings were secret, and they were not supposed to be released. Okay, this is INSVAP with, whether news you make public or not. But the wrinkle here is these were not meant for public consumption. This was meant for a private audience. This is a journal. Madison told his wife, Dolly, to sell the notes sell the notes to the Congress, if it was still in existence, I suppose, after his death. This is indeed true. Dolly Madison only sold it after Madison's death. So Madison crosses the Delaware. Pennsylvania and New Jersey are covered by the Delaware River, and he files suit in New Jersey. His claim was based on Situation publishing the notes based on the common law of misappropriation of property. Again, no statutory issues, all common law. Situation already creating trouble in the Jurassic era at the time of Magna Carta, ignores Madison's suit. All right, new time period. Sky turns dark, wormhole opens up, and they suck in the friends and bring them home to Seaside Heights in the year 2014. On the return, Bookie becomes celebrity, and her distinctive image appears all over the media. Okay, Bookie learns that the Seaside Heights t-shirt shop, this is where they actually worked. For those of you who actually watched season 1 of Jersey Shore, which you ought to, they were supposed to have jobs, and they were actually supposed to work at the t-shirt store. And Danny was actually supposed to be like kind of the host of the show. That went away because the characters took over. But the initial, I actually had a t-shirt made there. I went there. Danny made me a t-shirt. It was one of the highlights of my career. Although the saddest that day was, it was a day they were filming outside, so the cast members were not there. I was really bummed. Vinny was not having it that day, so he had to do it somewhere else. I actually hold the distinction also. I went to all 3 of the homes. I was actually in Miami. I went to the hotel they were staying at, not when they were there. And I went to Florence, Italy, and I paid homage to the pizzeria they worked at. So they tell you this after the evaluations, of course, if you question my judgment otherwise. I'm from Staten Island. This is a very influential part of my childhood. You ever question my Jersey Shore?
A little bit. Is it okay to assume that people from New Jersey are savages and don't have to like That's what I want to do. Like, clearly, he can't take the land over. He's a savage.
It's a Jersey thing. You wouldn't understand. So, anyway, so the t-shirt shop is selling a t-shirt with an image of a attractive female dinosaur with makeup, leopard print tights, and a hair bump. And it says GTL, gym, time travel, and laundry. This is the parody of the Vanna White. Remember the robot that was with the wig? Okay, so after leaving the gym, Bookie says, hey, they ripped off my image. That dinosaur is me. And she sues the t-shirt shop for unlawful appropriation of image. All right, keep going. We're almost there. So in anticipation of the 800th anniversary of Magna Carta, Bookie takes a trip to Runnymede, England, where she claims she still owns. Like, hey, I got this 800 years ago. It's still mine. I'm still alive, right? Life estate. Situation comes with her. So then Bookie has the bright idea of visiting Buckingham Palace to drop in her distant cousin, the Queen. Elizabeth, after all, Bookie is still queen, right? She's still alive and she's pregnant. She's next in line to the throne. Her child, take a seat, Prince William, right? But Situation has other plans, and he takes the pair to a soccer match, if you will. People always die in horrific ways, and they have to die suddenly. That's the way these questions work. So there's a game, there's a horrific riot, and both Bookie and Situation are simultaneously killed in a stampede. The NHS, National Health System, after some delay, is able to deliver the baby from Bookie's corpse. This is implausible, but it happens a lot in my exams, where children are born after the mother dies, because it creates very weird wrinkles in time. So with no parents, the doctors call the child John II, right? So basically, a person's born to someone with no parents, and that screws up inheritance, which you'll explore in a couple minutes. Almost there. So now Awa is appointed as a guardian of John II. She's also designated as the executor of the estate. Okay, the entire executor business is not particularly important, but it's simply a way to vindicate someone's property interest after they're dead. That's all it is, right? You don't need to know about wills and trusts. They're simply acting in the interest of the person who died. I do a lot of executor stuff. Okay, E is appointed as executor of Fitch-Waitman's estate. Okay, so A is for B, and then E is for F. Okay. Due to the bizarre nature of the situation, all the cases are submitted to the judge in New Jersey. Okay. The New Jersey legislature has passed a statute that grants jurisdiction over all matters to this court. All statute limitations are waived, so this judge can resolve everything. This is where I have some fun also. So to further the research, the judge visits the Magna Carta exhibit, the Museum of History. It's gone. It's too late. You can't go anymore. You should have. The Magna Carta display at the museum is not the original one, but a copy made in 1217. And indeed, most people don't know this, but within a couple of weeks of Magna Carta, the Pope annulled it. The Pope annulled it, and then they issued another version with various revisions, and it's complicated. But this was a later copy. So during those 2 years, a number of changes were made, and they deleted several provisions unfavorable to the king, which is true. So then, he stares at the 8th century document, and he sees it. On the first line, the letters B-O-O-K-I-E are bolded. Bookie. Message from the past. So we have the New Jersey Code and Da Vinci Code, in case you didn't get the reference. Late at night, he snuck into the museum. There's like national treasure stuff. He opened the glass case, and he saw a never-before-seen 30th article. There were 37 articles. He saw the 30th article. And it reads, all land that has been granted by King John would never escheat, but will revert to the heirs of King John. Oh. Now, the escheat, or the escheat, happens when a person dies with 0 heirs. No heirs. Then it goes to the state. And because Parliament never repealed it, it's still in effect. All right. So now we go down to our questions. Okay. I'm sorry, let me pause. I'm talking a lot today. Any questions on the fact pattern so far? Again, it's fairly long and involved, and I do this because I really want to give you stuff to think about. I don't know if they're all going to be quite this long, but this one happens to be longer than probably average. I think the first question is a little bit much shorter. Yeah.
I just had a question. What's the purpose of the 38th article given the federal ideas? Because I was trying to figure out how that fit in.
Well, is it clear?
Well, we're told that Elizabeth isn't there.
Question. Okay. So the first question, okay? The first question, sorry, let me ask you a question this way. An argument can be made that the child born from Bookie had no heirs. But that's not necessarily the right answer. It could be. But that's, I think, what I was getting at. But I didn't want to leave you hanging too long. So the first question, okay, so E asked the judge to adjudicate the situation in Rex dispute. And did the Jurassic Court have jurisdiction, or the GTL jurisdiction, right? Okay, I'm not asking here about the rules of civil procedure and jurisdiction, right? I'm not asking about whether the man in controversy was or not. I'm asking about in sort of state of nature. When one colony says, I am making my own kingdom to your exclusion, who owns it? That's what I'm asking about. So let's bring up with your classmate who, by my math, is taking the bar this summer. All right, yeah, they're almost done. They as you will be in 2 years. Get ready for it, folks. Okay, so question number 2. And again, This is 500 words. You had 1,000, so you have basically twice as much. Although, I think as you'll see, every question I ask can be answered in 500 words. But the forces that be intervene, so now it's 1,000. So if the judge follows McIntosh, he's likely to declare the non-Christian dinosaurs to be savages incapable of holding title that may only apply to the king of Jurassic. Now, Cody may hold that the Jersey people are the brutes, but you know, I guess I'd accept either answer. So the court would validate the situation's acquisition by discovery and establishments, right? So the key point is he discovered this place, even though there were pre-existing people there, they were savages. And then he established his own jurisdiction by planting a flag. And with that, he can have his own court system. I would gladly accept the other answer, that the dinosaurs are not savages, that they built their own society, that they have their own courts, right? I'd go either way. I'd even accept Cody's answer saying that the Jersey people are not savage and they are not able to establish a civilization. If you don't agree with me, drive in the Jersey Turnpike during rush hour on Memorial Day and you'll see the correct answer. Yeah. Yes, ma'am.
So we were supposed to think that they were.
All the above. Yes, no, I don't care. Right? But the issue is, if you want to say that the dinosaurs, were not savages, the fact that they've had a language, right? They built courts, that's pretty good for me. Or you can say that they're savages. I think actually the better answer in this question is that they weren't. Right? You have to suspend your disbelief, right? You have to suspend your disbelief for these questions, right? The fact that they're going through time and making contracts with dinosaurs is a little outlandish, but it's still, something to think about. The question continues. The Jurassic Supreme Court's approach incorporates Locke's labor theory and the ruling Genn v. Rich. Good. Tell me what case you're talking about. Tell me what theory they're applying. Were hunters' efforts rewarded to create incentives for hunters to maximize. Okay, that's a very succinct explanation. A very succinct explanation of why the sort of labor theory works. But then the student says the other side, the downside, that's difficult to determine when and where the hunting begins, and to compare the moment of the amount of effort, right? This is a problem with labor theory. It's very hard to calculate. It's not very certain. So right there, the GTL Supreme Court mirrors the Pearson v. Post approach, following the rule of capture, which provides a high degree of certainty. And it may discourage hunters if fear their prey could be taken away. The student says, I'll begrudgingly choose the Jurassic Supreme Court because it favors certainty. That's a pretty solid answer. I mean, it answers my question, first of all, but it explains the policy reasons behind each of the rules. And I think also nails how the Johnson versus McIntosh issue should be coming up. That's a pretty thorough answer, and it's not even close to the word limit that you guys have. Questions on number one, or things that you wrote, or things you want to ask about? Yes, sir.
500 for 1,000 word limit. Is that for all 5 answers?
Is that what you did?
No, I made a mistake.
What, you were 1,000 for each?
Well, I was trying to do that, but there's not enough for.
Yeah, no, don't do that. I'm not meaning to pick on you, but I said this dozens of times. It's 1,000 words total. Not 1,000 words for each of the 5. It's 1,000 words total.
I mean, if you're reading it on its face, it's kind of it goes away.
No, it can't. And I said this dozens of times in class. It's frustrating because no matter how many times I say it, people still make the mistake. It's really not. It's a total of 1,000 words for the question. Okay, don't do it. All right. Any other questions? Number one, substantively.
Just to clarify, it's 1,000 words per question. So in other words, our total will be 2,000 or less.
Yeah. I mean, I don't mean to be pedantic here, but you guys can be lawyers, right? You're gonna have word limits on briefs. This is not beyond the realm of possibility of things to think about. I mean, to give you a sense, a Supreme Court brief is an amicus brief of the Supreme Court is like 7,000 words. This is to make a very significant issue of constitutional law. Like 2,000 words for a proper exam is more generous than you'll ever have in any court. So this issue, it frustrates students, but you're gonna have to deal with this in a much stricter way.
Because you are giving more the double rewarding a limit. Are you expecting more than previous? Like, for example, would this answer still
It's still an A. This is why the entire word limit's a myth, right? I have had students who've given me 600 words last year who got an A. It's quantity does not help you. In fact, it often hurts you. I was meeting with a student earlier today who on her midterms, with my other class, on her midterm, she went above the word limit. And she didn't get the best score, but in her answer, she gave me stuff that was good and stuff that was bad. And it was painfully obvious to me that she wrote both because she didn't know what the right answer was. She didn't know. She's like, well, this maybe, this no. The word limit forced you to give me the right answers. That way I don't have to sit there guessing if you know it or not, but you're throwing everything in your notes at the outline. But that's why I do it. It's a fairness measure. But yeah, this would have gotten, even with the expanded word limit, this would have gotten 10 out of 10. 10 out of 10. I mean, if you're writing 999 words, you're not getting much more. But you know, it makes students feel better. I don't know the word to say it. It's about making students feel better, feel more comfortable, but it doesn't actually make any substantive difference. I can usually tell after the first couple sentences what the score is going to be. It becomes very painfully obvious in the first few sentences if the person knows it or not. Everything after that, you know. But I read every word. Yeah.
I was a little bit thrown off by when you ask about jurisdiction, and I know you have said that really it's nothing related to civil procedure. So when I'm reading these questions during the exam, if there's a word that actually kind of like makes me hesitant, I should just think, okay, we have to have covered in the course.
Yeah.
That's it.
Yeah. I mean, the issue with the jurisdiction was this court properly constituted? Right? Was this a properly constituted? Remember the Spelunking Explorers? Remember we did that? And we actually we discussed this idea of, you know, did a civil court outside the cave have jurisdiction of a crime that wouldn't happen inside the cave? I mean, that's actually what I was going for, right? Did this civilly constituted court control this sort of secluded world inside the cave where they had no reach to them? Right? There was even a line in the Spelunking Explorers that were the process servers, right? Could you serve process in this cave? And they're being facetious, but they're trying to make the point. So I mean, this was stuff that we covered, and I realize it's, you know, it might not be obvious, but that's what I'm testing. It's going to be stuff that's not entirely obvious that you'll see, you know, kind of at an angle. Yes, ma'am.
Doing the word count, do we just need to press the button and then it's going to tell you how many words, or do we need to write at the bottom?
Did you hear what I said before about the word count feature?
Yes, but I know we have to push certain
Stats.
buttons,
On the right side, I think it says stats, and they'll give you the word count.
Right, but at the bottom, do we need to say this is how many words?
No. When you don't need to tell me. It prints it out automatically. Yeah. You have no idea, when you become actual lawyers, word counts are going to be your biggest determinant in life. Because every brief you write is like, oh my God, the word count. I mean, it's such a concern. It's so distant for law students, but this is like the primary thing that lawyers have to worry about when they actually litigate. It's some courts have page numbers, some courts have word counts. It varies by jurisdiction, but this is basically, how can I do the best job for my client given the constraints I have? I mean, this is you know, this is the issue. In fact, the federal rules of civil procedure and the federal rules of appellate procedure are considering shrinking the word limits because lawyers write too much. They write way too much because they can't be concise. You can't put every argument you want in a brief. It's not possible. Indeed, it's often not advantageous because when you lead with your weak stuff, it actually hurts your case. Right? I mean, I realize it's a concern that's foreign to law students, but trust me, you'll remember this in a couple of years when you have to start putting an appellate brief under 7,000 words or 10,000 words, whatever it happens to be. All right, anything else? Question number one? The other one is calculating statute of limitations. Learn how to count days. Learn how to count days. 1 day late means you lost. Right? You have to, learn how to count your days. Deadlines. 25 days, 30 days, count them, because that's how you get malpractice claims. Okay, let's go to number two, and let me go back to the question. Okay, number 2 says, identify the present and the future interests of Runnymede in the year 1215 after King John's grant for bookie, fituation, King John, and King John's heirs. Okay, so let's go back up to the grant. Okay. Second. Okay, so it says here. Everyone see it? Yeah. It says Runnymede from King John to bookie for life, then to fituation as heirs, but if fituation does not survive bookie, then Runnymede to King John and his heirs. Okay. So we have here, before anything else, John owned in fee simple. Indeed, the king, as a matter of common law, owned everything. All the land belonged to the king. But he gave bookie a life estate. Okay. So do we have following the life estate? Okay. We have a remainder. Okay. Now, what kind of remainder is it? Well, it can be contingent or it can be vested. But it says here, the fituation's heirs, but if fituation does not survive bookie. Okay. Does this remainder follow some sort of condition, or does it follow naturally after the death of bookie? It follows naturally after the death of bookie, which tells us the remainder is vested. Okay, it's a vested remainder in fee simple. However, there's this but if at the end. But if fituation does not survive bookie, that is, fituation dies first, right? He dies first. Then what happens? Runnymede goes back to King John and his heirs. So what we would say, and I think this is the best answer, but open to others, is that it's a vested remainder in fee simple, but it's subject to divestment if the fituation does not survive bookie. Okay, so then who has then the other future interest? I would say that the king has executory interest. Now, is it springing or shifting? I'd say it's springing because it's going back to the original grantor. That is, if the fituation does not survive bookie, it goes to King John and his heirs. So this is why the wrinkle is, if fituation dies first, right, then it goes back after bookie's death to King John. What makes this question difficult, of course, is they died simultaneously. There's going to be a lot of simultaneous deaths on my exams because it makes things weird, right? But I think here's what the student wrote for the A+. I think this is pretty good. Bookie is a life estate. Fituation is a vested remainder in fee simple, subject to divestment. If F doesn't survive B, King John is a spring executory interest in fee simple if F does not survive B. And then the king's interest is sent to his heirs because it's in fee simple. Again, you don't need 1,000 words to write this. It's 15 words, 20 words, whatever it is. Right? I think that's pretty good. Now, I will entertain other ways of reading it, but I think this is a good answer.
Would it have been better to say why it was been vested remainder? Say they were ascertained?
Yeah, I mean, you can. Yeah, I mean that would always be better if you would say the reason why it's springing because it goes back to the grantor. The reason why it's vested because it follows a natural death. As an ascertained person. I mean, yeah, you get that stuff. I mean, this is probably 7 or 8 out of 10. I mean, it's exactly correct, but a little bit more meat can get you up there. Sarah?
Is it all right if I ask why it's not a reversion and instead of springing executory interest? I've forgotten, and so.
Why King John does not have reversion?
Right.
I think about your answer for a second. So I think the short answer is in most of the examples we've done before, when you have a future interest that divests after a vested remainder, it's better thought of as an executory interest. A reversion is, generally speaking, from O to A for life, right? Period. We'd say that O is reversion because as soon as A dies, it goes back to the grantor.
Is it because it was an uncertain reversion that it's an
It's
spring is
not the reason why I think a reversion is not the best answer is because this can cut short someone's interest, right? Because the second that Fituation dies, his heirs have their interest cut short. Even if Bookie's still alive, right? Bookie can still be alive. She has it for life. There's nothing taking it away from her. But the second Fituation dies, his heirs just lost out on a future interest. And I think that is what happens to the springing executor interest, actually cut short that interest. Yeah, Carl?
And isn't it true that a springing executive interest occurs? It goes to a third party from the grantor. And the shifting is when it goes from a third party to another.
That's correct, yes. That's why it's springing, exactly.
And it's springing because it's coming
Back.
It's going back to the
Yes.
grantor and then springing from the grantor.
Well, it starts from the grantor, it springs from him, and then when the condition met, it jumps back to him, right? It cuts short. Because as this is phrased now, let me go back to the question. Fituation and his heirs have a future interest, and they have that. But the second Fituation dies first, that interest disappears. And what cuts short that interest is the springing, the executory interest of the king. The king's interest cuts that short once Fituation dies. That's why I think it's better characterized as a springing interest. I mean, you could maybe call it a reversion, but I don't think that captures the full extent of what's going on here. Springing, I think, is a better answer. Is that Carl's answer your question?
I was just trying to say, why are we naming it a springing executive interest? Because it's going to.
I'm sorry. Well, Bookie has a life estate.
Bookie has a life estate.
That's fine. But we're talking about it's springing because it cuts short the heirs of Fituation.
And in order for the king to receive the property, it's going to come from Bookie. If King John.
He can only get it from Bookie. That's right. Because if Fituation outlasts him, King John never gets it.
Right.
That's right.
So in order for it to spring, it would have to go back to the grantor. Spring to the third party.
No. If Fituation dies, King John simply has, and his heirs simply have to wait for Bookie to die. This question, though, should live for like 800 years. So, right, does that make sense?
I understand.
I saw another hand there. I think your hand was up.
I'm just trying to figure. I'm a bit confused between springing and shifting because, the way I understood it, I thought the shifting executory interest functioned to cut off the interest of the third party, whereas the springing cut off the interest of the third party. But that's
I think in this case, the springing reflects the fact that it's going back to the grantor. I think that's what your question is, right? Okay. Other questions, number 2, please. Okay, no other questions, number 2? All right, let's go on to number 3, please. Number 3 asks, okay, the Montpelier Foundation is charged with protecting James Madison's estate, and it reopens a suit against Madison. Again, there are no statute of limitation issues. Because his claim was brought before any statutory law, it wasn't even a constitution yet, please address the issues under the common law doctrine misappropriation of property. Okay, so again, this is the INSVAP case. The student wrote, the conventional, oh my God, conventional, constitutional, the Constitutional Convention, oh, God, breaks my heart. The Constitutional Convention, I didn't take any points off for that, but the Constitutional Convention notes taken by Madison, he had intent to later publish them after his death, which is important. should be viewed as creation of property since it was protected from copying in the INS versus AP case. Madison fashioned the words in the journal for his own observations. These concepts and words belong to him and cannot be copied by F. And they actually quoted from it, until the commercial value of the news has passed away. So this is actually one of the questions in INSV AP, right? Okay, this is actually one of the questions. The reason why the AP was asserting this claim was because they actually sent reporters to the war, right? They had reporters overseas who were trying to report on all the events from World War I. This was meant to be public. It was meant to be known. These are things happening in the world. Here, though, we have a slightly different situation. These were meant to be secret for decades until Madison's death. And indeed, he told his wife, don't release till afterwards. So I think here the claim for protection is far stronger, right? The claim for protection is far stronger. However, right, does that mean he can sue for it? So what did the student write? Okay, since Madison, okay, assuming Madison's account is the only one in existence, his account doesn't lose commercial value until he publishes it. Because it was never actually published, there's no claim that can be used as a matter of reporting on news, which is a private affair. Therefore, Fituation is liable to the estate. Again, I think that's a pretty solid answer. I think they hit, you know, just about all the bases. Yeah.
I guess I'm wondering about the commercial value.
I'm sorry?
I'm wondering about the commercial value because it's going to be given to the state. Given to the state, does it not have commercial value to the public?
No, an estate can make profit. There's nothing wrong with that. An estate can manage. I mean, when even today, right? Even today, copyright it survives for I think what 75 years after a person's death. So even after the death of Elvis or whoever some phrase, the death of Michael Jackson, right? Every time a Michael Jackson record's played, his estate's making money.
It's state, not us state.
Oh, I think it's an us state. I'm sorry, I misheard you.
It's being given to the state.
Which state is getting here? I'm sorry.
Or didn't we say give it to the?
I think
his wife's job to give it to
Congress.
Okay. My
Okay.
mistake. I missed.
Although it's true that Congress can't hold a statutory copyright, you can still profit. I think actually, I can't remember if Dolly Madison ever made money. I think she sold it, and you can actually have a licensing agreement to sell something to Congress. And there's nothing wrong with it. Congress can buy stuff. Yeah, they're allowed to buy stuff. Okay, what do you got? Questions on 3. Questions on number 3. Nothing? Yes.
Is there a possible argument that the stuff was news and wasn't? I mean,
Sketch it out. Explain your argument.
okay, I guess I argued both sides. I wanted to say, well, it was misappropriation, just like what he said in his number 3. But then I argued for F side to say that it was newsworthy. And that there was
Yeah.
maybe not copying the exact same words, but giving the gist of it.
Right. So this is basically the INS argument that news is for the public. It's meant to be known.
Right.
I think the reason why that's probably not the stronger argument is that this is something where they close the window, they put a guard at the door. This was not meant to be known. And I mean, it's a matter of history. The fear was if word leaked of what they were doing, they would not be able to finish. And they were working in entire secrecy.
I see. So the Constitution wasn't done yet. That's
No,
what made
this is
it.
what they were writing it.
I got
And they feared that if word leaked out, the entire project would be spiked beforehand. This is why when people say we have a democratic constitution, I have to laugh. Our entire founding charter is written by a bunch of the establishment, so to speak, in a closed-off room where no one could go. I mean, for another day. Any other questions, number 3? Okay, so number 4. The question in number 4. Okay. The question number 4. AWOW brings suit on behalf of Bookie's estate against a t-shirt shop for unlawful appropriation of Bookie's image by creating the t-shirt. Yeah, this is the t-shirt with the dinosaur with the makeup on it, right? Please address the strengths and weaknesses of this claim and decide if AOL is likely to succeed. Okay? So what do we have here? This is, again, the Vanna White case. The student wrote, if the dinosaur's image, if the dinosaur images, weird possessive, if the dinosaur image's likeness to B is equivalent or greater than the likeness of the robot in Samsung's commercial to Vanna White, then we apply the holding of White v. Samsung. Okay? We didn't do the Kaczynski case, did we? Did we? See, unfortunately, this actually kills me. When they updated the new edition of the case book, they took a case out. You didn't need that to answer this question, but there was actually an opinion from Judge Kaczynski in the Vanna White case that I think significantly made this more interesting question. But we're given this insight by Kaczynski in the dissent that the judge rules in B's favor. He's actually expanding B's rights rather than protecting her right of publicity. If the judge D rules in favor of B, he has prevented teachers from capitalizing her likeness, and that minimizes the world's fair use of parody. So, I mean, there's a couple of things here that I like. They discuss the Vanna White case, the Samsung case. They discuss the value of a person's image. They'll discuss parody, which is something that was an important part. We need to be able to laugh at society. Yeah, this is probably not a 10. This is probably like an 8 or so. It's a good answer, but it's not awesome. But I think it hits all the bases. Did anyone else write something different that they think contribute to this? Yeah. Let me go back to the question and read it again. I think the person could have sketched out perhaps the harm to Bookie, right? Think of Vanna White. Vanna White actually asserted that this is stealing all the hard work that I put into creating this image, right? With the hair and the makeup and all that stuff. It was actually Merv Griffin, but we'll put that aside for now, right? Bookie made an image of herself with the hair and the makeup and the bump and you know, if you look at any celebrity, right, that you look on, you know, any supermarket magazine, they put a lot of work into their image. And that perhaps something they should be rewarded for by controlling the use of their image. So perhaps students, we're not very elitist in this room, I don't think, don't have a lot of sympathy for the celebrities, but that I wrote strengths and weaknesses. I mean, so there is a claim for why perhaps we should allow celebrities to sue when their images are appropriated. But you know, it's a good answer. Don't get me wrong, but I don't. That part was absent, I think.
I kind of wrote like supply and demand. Once the market for image, the demand for it goes down, that kind of stuff.
Yes, hence season 5 of Jersey Shore, which no one watched. It's true, right? When there's overkill of one image, it loses value. It dilutes it. So if there's too much Snooki or Bookie, as it were, it actually makes it less worthwhile. And this is why, if you ever go like the paparazzi, you're always thinking, oh, they're intruding. These are mostly set up photos. They actually agree with the paparazzis in advance to photograph at a specific time. They want to make it look like they're like, you know, frazzled, but they coordinate with these photographers. It's done very deliberately. Celebrity is fascinating if you want to study from an IP perspective. They don't mind the paparazzi as long as they're getting paid for the photos. Let me put it that way. All right, questions number 4. Not too hard, right? Not too hard. Yeah, I think the last one, this was maybe the question before, it's probably the trickiest one. And I wrote this in a very disjointed manner because I wanted to, on the way out, give the students a chance to show me they know what they're talking about. Okay. So number 5, Queen Elizabeth II, the monarch of the United Kingdom, and a very distant heir of King John. You know, they're all related, the royal bloodline, right? Files suit to quiet title on Runnymede. AWOW intervenes, and recall that AWOW is now the executor of the estate of Bookie. And as such, she is the guardian of John II, right? The infant born after the soccer riot. Please address what interest, if any, that Queen Elizabeth has, the heirs of Fituation has, and the little boy, John II, has in Runnymede. Okay? Again, this was the hardest question by far. And what will drive you nuts is I don't have one answer in mind. When I write this, quite literally, I throw all of these different wrinkles together and it's like, you guys figure it out. So I don't have an answer in mind of how this one comes out. I don't have an answer key. I want to see if you can come up with the various ways. And usually, most people find, I have 80 of you guys in the class, 4 or 5 answers usually people settle in on, maybe 1 or 2 outliers. So what this student wrote is, whether referred to the grant given in 1215 or to the newly discovered 30th article matters not. Well, I like that. Good writing. By the way, if you notice, there are no typos here. I don't mean to be a typo or grammar Nazi, but write well. You're lawyers. That's what you do. And I have to admit, when I see a paper that's written with poor spelling, I assume it's sloppy in other respects. You're going to have to write a bar exam in a couple of years. And if you have it littered with typos, you can guarantee that the person who reads 100 of these things a day will be like, oh man, this is crappy. So you don't have spell check, but learn how to spell. You're lawyers, right? Learn to write. This is all, very little of what you actually do, unless you're maybe a public defender, will actually be in court. Most of what you do will be writing. If you're a prosecutor, public defender, you're going to be in court every day, one after another. But most lawyers write. So student wrote. Doesn't matter. In both cases, Runnymede belongs to the heirs of King John. Okay, let's go back to the grant. Okay. So this one says, all land that was granted by King John will never escheat, will revert to the heirs of King John. Okay. The first one said, if Fituation does not survive Bookie, then to King John and his heirs. Okay. So here's the wrinkle. And again, I don't know that this is necessarily the correct answer, is that they died at the exact same time. How does that work? Right? How does that work? Did Bookie die first? Did Fituation die first? Unclear. So what happens with this sort of future interest where the life estate terminates and then immediately what happens? So I think probably the best answer is that King John gets it because they both died at the same time. But I don't know if it's entirely wrong to say that because Bookie had the life estate, that terminated. And the second Bookie's life estate terminated, you go to Fituation. I think that's probably the weaker answer, but I mean, I can see someone writing that as well. The other tricky aspect is it goes to King John and his heirs. Okay. Is the child born after the mother's death an heir? Let's say it again. Is the boy, John II, who was delivered after his mother died, an heir? I don't know. I mean, it's certainly his blood, right? It's certainly his bloodline, but there's a gap. And the child basically was born to the world with no heirs. The child was born with no heirs at all. See, his mother was dead. He had nothing. I'm sorry. I don't even think it was his mother because it wasn't delivered from her. Now, I think the modern approach is saying, of course, it's a tragedy if the mother dies and then they deliver the infant from the womb, right? Of course, that's the mother's child. But if you think about it carefully, there's a gap. There's a gap in time. And property can never be without an owner. So let's walk through this with me, right? Just walk through with this for a minute. Bookie and Fituation died instantaneously. The moment they died, it goes to King John. King John's dead, so it goes to King John's heirs. At the instant B&F died, who are the heirs of King John? Not Lil John, not the boy, because he's not born yet. He was only born moments later. So I think at that point it goes down to the heirs of King John, which is the queen. Oh, that is what I had in mind. I realize that's somewhat demented and twisted, but at the instant in time where they both die and it goes back to King John, John's dead. Who are his heirs? Queen Elizabeth. That instant, that moment, even if like a minute later, the NHS finally delivered the baby because they're, universal health care, there's still a gap. And the way this works is instant. Dead, dead, boom, King John heirs. You don't wait and see. So I think the best answer, I can't remember what the student wrote. I think the best answer is that the queen gets it. Okay, Sarah, a second. Let me finish reading what the student wrote here. With respect, F did not survive B, triggering the executory interest, F of his interest, which give the right of mid to King John's heirs be simple. So EF has no claim. I think that's right. However, both QE2, that's actually your nickname, Queen Elizabeth II, QE2, and J2 descendants and heirs, they have an interest proportion. See, I don't think that's right. I think, literally speaking, Lil John, King John II, has nothing at all. I think it all goes to Queen Elizabeth. But I'd be willing to entertain other things. So, yes, sir.
What would Bookie's child even be in the question? It doesn't say to Bookie and her heirs.
But who is the father? Who is the father of the child? There you go.
My question is actually very similar to his. King James had already died.
Who's King James? Yeah.
I got the
That's okay.
wrong. But he's already dead, and his heirs would have been identified at his death, not at Bookie's.
Right, but a child in utero can be an heir. As long as a child's in utero and the woman's pregnant, that's ascertained. Granted, it took 800 years for him to be born, right? That's a bizarre situation. But at the time of his death, there was a child in utero. And that is an ascertained heir. 1 second. The moment, walk with you, right? On their wedding night, they got pregnant, right?
Okay.
They got pregnant on their wedding night. She had a belly, okay? That is an ascertained heir. Granted, it took 800 years for that gestation. It was the longest gestation in world history. But King John died, let's say 1240. I don't know what year, but at some point. When he died, that heir was still in the uterus, was still in utero. Now, no one raised any claim to Runnymede for 800 years. But that doesn't mean it didn't go on to someone else, right? That no one asserted a claim to Runnymede for 800 years doesn't mean that someone else had the interest. Okay? Technically speaking, right? Technically speaking, if you had to ask me, the second King John died in the year 1240, okay? If someone had brought a lawsuit at that moment, John II wasn't born yet. He had not been born yet. But the fact is the lawsuit was brought in the year 2014. So now you see who are the heirs now, who's still alive, who's still around. And I think John II gets nothing because of the circumstances of his bizarre birth.
I guess I'm confused how he could be an heir while he's in utero, and then he loses that when his mother died.
If he had been born normally, right? Bookie did not get killed in a soccer riot. He would have been an heir of King John the same way Elizabeth was. If he had been born in the normal course of delivery without this bizarre death, he would have been heir of King John. And in fact, he would have been a closer heir to King John than Elizabeth was. Elizabeth is a distant, distant cousin.
Right.
So what makes this question different is the bizarre circumstances of his death unheired him, right? He was not an heir at the time of the death of John. He was looking at this question now in 1215. He was no longer an heir when Bookie died. Because after all, Bookie had a life estate. You don't assess any of this until Bookie's dead, right? Bookie, she lived for 800 years, right? But Bookie has a life estate. I think that's what you're asking, Kip.
I guess, yeah.
Yeah, okay, it hit me.
You don't ascertain anybody's heirs until she dies.
You don't figure out anything. Okay, I figured out mid-sentence what you were asking about. Bookie was still alive, and until Bookie died, you don't do anything. She lived for 800 years, Methuselah, right? She's around forever. But until she dies, you don't assess anything. Only when she dies, you calculate who King John's heirs are. Yes, Jessica, please.
I'm sorry, I'm so confused with that one because precisely because Bookie dead, that then all the heirs are ascertained.
When Bookie dies, is John alive? Little John?
In the uterus.
No. When Bookie dies, right? Is John II alive yet?
Not yet, has not been born.
Okay, so
But the fetus
are
is
you
alive.
saying that the fetus that John's fetus could have inherited the property?
Yes, because I mean,
Oh, see, I always say that's interesting. So that's an interesting answer. So I think that's actually also right. You could also say. You can also, okay, that's actually good, Jessica. I didn't think about that. You could also say that because John was the heir, at the moment his mother died, he was still in utero, so then he would actually get the interest in the property. Ah, that's interesting too. Let me think about that for a second. John is in the uterus. Because fetuses can inherit property.
It's not more
They can.
They can or cannot?
Oh, they absolutely can. Yeah.
one live breath.
No, that's Planned Parenthood Casey, my friend. Not you're in the wrong class. You don't take a breath. Fetuses can inherit property. That's absolutely right.
Okay.
So in that case, if you'd written that, that'd be correct. I can't remember if anyone else wrote that, but that's a good answer also.
So we learned about abandonment in cases specifically, and we also glossed over adverse possession.
Oh no, we do that property too. The answer is not adverse possession.
Okay, but
And generally the answer is you can't adversely possess against the state. So if there's property owned by the government, you can't adversely possess it.
Well, Bookie was the one that had the interest, and she wasn't the queen, I guess. I don't know.
Yeah, I mean, I was afraid someone would write about adverse possession. I was really hoping they wouldn't. You haven't learned yet, so that's not the right answer. You'll do adverse possession and property too. Adverse possession is what you might know as squatting. So the short answer is, if people were living on Runnymede for, I don't know, 800 years, and the true owner didn't assert his or her claim, then the property is actually lost. But you haven't learned that yet. Put your hand up.
I was just wondering if you can totally ignore it in the future, but I know you put the 8 plus total answer, but I was just thinking it might be more effective if each one had
Oh, the
like
10?
the 10 or the highest one.
Oh, that's interesting. That's
Because
a
that
good
way then
suggestion.
you probably not have as many questions fighting over why that's the
Oh,
8
come
plus.
on. You're still going to fight. No, no.
But it might be helpful
That's
to
it. You know what?
the 10 or the highest.
I'll do that. That's a good suggestion. I'll do that. And for your, when I post, when I finish grading, that's a really good idea. And I'll do that. I hadn't thought about that. John, gold star. Anyone else? I want to make sure I spread the wealth. Yeah, Carl.
When we were talking about lieutenants, I want to go back to the adverse possession comment.
We haven't learned it.
Well, we learned Hauser, then what occurred, like, in that, like, considered adverse possession.
No. I mean, you learned about Alfred the co-tenant, right? But you can't adversely possess against a co-tenant. Yeah. The fact is you both have a legal claim to the property, so the part is you both have access to the entirety of the property, right? So you can't really adversely possess.
Oh, but it's just Hauser.
Yeah. Yeah. Adverse possession applies if like some other random guy is squatting on your property and taking it.
Sorry.
That's okay. I'll make sure everyone gets a chance to answer questions first.
I want to make sure that I understand the heirs thing. So an embryo can inherit.
Yes.
They are.
Well, if it's fertilized, embryo's an egg, but a fertilized.
Right,
and-
okay, so a fetus.
Thank you.
Is.
Thank you, Jaime.
a-
I said Jaime.
Yay!
Yeah. He corrected me last week, so it only took me 18 weeks.
So the fetus is an ascertained heir, is that what you're saying?
Yes, ma'am.
So
Yes,
they are
ma'am.
an ascertained heir, And so if the future interest had been these heirs, the fact that she passes away first, does that not destroy the fetus's ascertained bestedness or whatever?
I think Jessica's answer is very interesting. At the instant Bookie dies, the fetus is still alive.
Right.
And at that instant, the property devolves to the fetus.
Oh, good. Okay.
I-
I learned it wrong.
I don't think this ever actually happened. This is purely hypothetical. I don't think there's ever been a case in recorded history where this actually occurred. But I think that's how it would work out. Again, there's no one right answer. And I mean, you give me an answer. All these answers are really good, and I would give ample credit if you actually explained it out. Right? If Jessica, if you wrote, well, because it was a life estate and Bookie died and the fetus had already been ascertained, then she gets interest. That's a good answer. Or if you're doing what I initially came up with, because at the time of the death, it immediately then devolves to the heirs, and then there wasn't an heir yet. I think it's a legitimate question. If when the mother dies in utero, is her in utero fetus still considered an heir? Because in every single situation in recorded history, when the mother dies, the child dies. Although with modern medicine, you can now extract the fetus from a mother. So I don't think the rules have quite considered that sort of situation, right? Usually when the mother dies, so goes the child. But due to the miracles of modern medicine, you can actually extract, and this happens, you can actually extract an infant from a mother's womb after the mother's already been dead for, hopefully some small period of time. I don't think the common law considered that specific question. It was more that the child died after the father died, right? Or imagine the situation, right? Husband impregnates wife on their wedding night. Husband executes some document saying, to my heir, so-and-so, and then the husband dies the next day before the child's born. That is what the common law is concerned about, children being born after the father's death.
I mean, I guess it's the policy reasons why, go with Jessica's answer, just also wondering, maybe grows a fertilized embryo, you essentially have a bank waiting for you.
Well, I mean, those cases are actually very tricky, and these come up. I think there might have been one reference in your case notes, but imagine, husband and wife, husband freezes her sperm, wife freezes her eggs, then they get divorced, and then the wife inseminates and and inserts into her body. Is that now an heir of the man? Now, perhaps he gave the sperm donation when they were married and wanted to have kids, but he, since divorce, says, I don't want that, screw that, right? And there actually are legal fights over things like Social Security benefits, right? Could that child then claim, the survivor benefits of the husband? And these are very difficult cases, far beyond, I think someone over there asked me about it that when we talked about this, but this is far beyond what I want you to think about. But this sort of question with this bizarre death gap birth raises these issues. Okay. Other questions on number 5? Questions on number 5. Questions on other stuff. Ah, there it comes. Yeah. Okay. I think your hand was up first.
So I'm unclear on this. Is this going to be like a midterm where we're allowed to have a sheet of paper?
I've said this many times. It's completely open book.
Okay.
I've said this many times.
Yeah,
Completely, you can read whatever you want.
As well.
It's the same rules. Whatever you want. It won't help you. It won't. It really. Did you, when you took this exam today, did your notes really help you?
Spelling for the case.
Spelling. And by the way, after you print it out, you can't bring your laptop. You need to print them out. You can't bring your iPad. You have to print it out. I've gone through this before. It's too easy to cheat, so print them out. Yeah.
I guess I'm a little bit stuck on number 2.
Okay. What do you think? Let's go back up to number 2. Hold on.
I think it should be shifting.
Why do you think it should be shifting?
Because in everything I have in my notes, spring is when you cut short the interest on the grant form. And in this case, it looks like he's cutting short the interest of the heirs propitiation, whatever. So wouldn't that be third party?
I think we had the same argument a few weeks ago. So at the outset, let me make this point. The phrases shifting and springing are not actually real things. These are things law professors created to try and explain things. So it's possible that the understanding of shifting and springing I have may not be consistent with the one you're reading about, which I realize is not a particularly reassuring answer. So my understanding of the springing, and this is how I thought I taught it, but when the future interest is cut short by the grantor, I consider that springing. And this is what's happening here. The future interest is being cut short by the grantor. And I'm not criticizing you. There may be some other resources or something else that suggests otherwise, but this is my understanding. And again, these are professor-made doctrines, right? If you ever are in court and you're trying to argue for springing or shifting, the judge will say, who cares? Doesn't matter. The fact that it's an executor interest means it's cutting short at the time of the death of B. Does that make sense? I'm sorry, the death of F, I'm sorry. Yeah, I mean, I think that's a better answer. I mean, I'm sure that can be argued also, but this is what I think is a better answer. And accordingly, if you are writing an exam for me, this is probably what you should.
Yeah, probably misunderstood.
I'm not faulting you. I'm sure you read what you read correct, but in terms of what I'm looking for, this is how I would view it. Professor-made law can be read in professorial ways. I saw another hand.
I just wanted to add on that real quick. I think the confusion comes up because, according to my notes, everything we covered in class was from the viewpoint of the third party, whether it cut off the interest of the third party or cut off the interest of the grantor. So in this fact pattern, the grantor
Cutting off.
the interest of the third party.
Yeah, it's almost inverted, right? It's
So
almost inverted what you said.
Talk about that.
Yeah, maybe I think that's it. I love when students ask these questions because invariably another student will have a similar reflection, so I appreciate that. This isn't exactly what we learned about, right? It's true that the interest of the third party is being cut short, but because it's being done by the grantor, I think it's better viewed as springing. Does that come closer to answering your question?
So in other words,
Adam, I think that was a good insight. I
So
think
when it involves the grantor, it's
I think that's a better answer. Yeah.
whether regardless of which side you're on.
Yeah, I think that's why. Yeah, I think. Okay, but you're right, Adam. I think your point's exactly right. That's what you learn because usually you're thinking of the grantor's perspective, but here it's the third. Sorry, it's the original guy coming in and taking away. And to my mind, that's. Again, these are judge-made. I mean, professor-made things. They're not written in any sort of stone. Yes, sir.
You're okay with it saying Ellie instead of Pipe State?
Oh yeah, that's fine. I can. Ellie. I mean, that's an easy one. I mean, the worst one was it FSSD, FSSE, FSCS. I mean, I know what you're talking about, but it's have to think about it. But yeah, those are okay. Other questions?
We're going through our outline and we have some more questions. Can you email it?
Yeah. Going once. Going twice. Good luck, everyone. I will see you at some point in the future. Thank you.
Thank you.
Thank you.
Thank you.